So there's two words that are really important when it comes to being fair in a trial. One is probative. Want to get to the truth, right? Want to get to the facts. But the other one is prejudicial. You don't want to go beyond that and actually like taint the process. You don't want to negatively impact the fairness. But you do want to get to the facts. But where do you draw the line? How do you know? Because it would seem to me that when you're trying to convict a guy, the prosecutors are putting on evidence that is prejudicial, like it's against the guy. You're trying to convict him. At what point does that evidence become a problem? That's the million-dollar question that Mark Geragos needs to answer, or Stacey Honowitz. Geragos is the trial attorney, co-host of Beyond a Reasonable Doubt, podcast with Adam Carolla, and Stacey Honowitz is a Florida assistant state attorney specializing in sex crimes. Okay, so Geragos, I'm going to begin with you. It's like that thing. It's like when the Supreme Court says, I can't define porn, but I know it when I see it. Where do you draw the line on whether the financial crimes, and there's just a boatload of them, right, for Alex Murdaugh, where do you draw the line that some of it has to come in because the jury needs to know why? Why would he kill his wife and his child? And then when does it just become a pile-on?
Well, this case is interesting for a number of reasons, and the fact that they've got so many counts is probably one of the more fascinating to me. As a rule of thumb, you gave kind of the legal standards that probably you do a balancing test, more probative than prejudicial. I have a more practical test. Most judges are ex-prosecutors. I mean, that's just the reality of it. And most judges tend to help carry the prosecution's water. And what do I mean by that? If they think the prosecution is losing, I tend to see where judges let more evidence in, more prejudicial evidence in. And especially in a circumstantial case, if it looks like it's almost completely circumstantial, which this case, at least so far, appears to be, then this judge has already telegraphed he's going to let it all in. I mean, yesterday, or this morning, I should say, he justified in retrospect letting something in yesterday by that famous expression where the defense had opened the door. If I had a nickel for every time my father told me, I've looked through the evidence code a million times, I haven't seen any code section that says open the door.
Okay, so then here's the thing, Stacey, is that let's just say, you know, for grins here, that the judge lets a whole bunch of this stuff in. And then the prosecutors are out having a beer that night thinking, look at us. We got this thing in the bag. But doesn't that ultimately mean it's kind of a win for the defense because you might actually have some material to appeal the case on?
Well, absolutely. I strongly disagree with Mark. I like him a lot, but I have to disagree with him in this sense. I don't think the judge looks at the case and says, this is so circumstantial and the prosecution's losing, so I'm going to let it in. This prior bad act evidence, it's 404 and 403 evidence. It's, you know, an appellate court, if this judge is going to let it in, an appellate court, like you said, is going to look at this very strongly. And what you have to remember is in your previous block, when the investigative reporter was talking, he said, well, I think he's going to let it all in. A judge will tell you, and you will hear from the bench, that you cannot make that the feature of the trial. These prior bad acts, these financial crimes, all of these things that he has done, while they are there, you cannot make that the feature of the murder case. And that is the problem when you are trying to get in this evidence. Now, the opening of the door, as Mark was talking about, is when a witness from the defense questioned a witness and then said, can you tell us any reason why this peaceful, basically decent father would ever take the life of his wife and his child? So now the prosecution is saying, wait a second, there are reasons. You have to know now about all these financial crimes that he is, you know, being charged with. Maybe he was at the end of his rope. And that's why we are at the hearing that we are today. It's an in-camera hearing. The jury's not there to hear any of this, to make this determination. But you're right. The judge has to be very careful because that is like an automatic reason for a court to
issue
reverse.
For an appeal. Yeah. Okay, so then the other thing is, Geragos, I have this question. If I'm sitting in the jury box And I'm wondering, up until now, you have never told me why this guy hated his wife so much or hated his kids so much that he would do this. And then you come out with this big old litany of financial crimes. I would be staring at you thinking, is that all you've got? Could it not backfire, Geragos? I mean, this kind of stuff?
I've made this argument successfully on a number of occasions, which is the reason they're bringing this stuff in is, and I tell the jury, I said, you're going to hear what I call the character assassination block of evidence, where the prosecutor's going to come up here, he's going to dirty my client up, repeatedly throw stuff out there that actually is under the guise of giving you a motive, but it isn't a motive. Where is the motive that he's going to be exposed for $750,000? Oh my God, now I'm desperate. I'm going to go slaughter my son. And it's just it's a non sequitur. Maybe it would be a motive if he had taken out the CFO. Maybe it'd be a motive if he had taken out one of his partners who was
exactly. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.